Welcome to the Lawyerist Podcast with Sam Glover and Aaron Street. Each week, Lawyerist brings you advice and interviews to help you build a more successful law practice in today's challenging and constantly changing legal market. And now, here are Sam and Aaron.
Hi, I'm Sam Glover.
And I'm Aaron Street, and this is episode 157 of the Lawyerist Podcast, part of the Legal Talk Network. Today we're talking with Shannon Salter about British Columbia's Civil Resolution Tribunal and how to build products for the public at large, similarly in the United States.
Today's podcast is brought to you by LawPay, FreshBooks, and Ruby Receptionists. We appreciate their support, and we'll tell you more about them later in the show.
So we've done this podcast now for over 3 years and have provided lots of cool guests and content for our listeners. And I feel like we probably, in giving all of that, haven't done enough asking in return. And I think we've got such cool ways for lawyers to engage with the broader lawyerist community and to help us spread the word about the great guests we have on the show that we wanted to take a minute and make 3 asks of you. At our TBD Law events that we do every year, we've developed a system of having people make unreasonable requests with the idea that every once in a while, if you ask a group of people to do something for you that's totally unreasonable and you shouldn't expect them to do it, that every once in a while they will, and that you can have some really great results from that. I'm not sure these requests are unreasonable, but we wanted to make them of you because we want you to be both more deeply engaged with our community and to help us spread the word about the work we're doing. Here are the 3 things we would love for you to do if you haven't already. Number 1 is to review this podcast in iTunes or Google Play, depending on where you listen to it. Those ratings and reviews both help us have a broader reach within those platforms, but also understand what people like about the show so that we can provide more of that. If you go to lawyerist.com/podcast, there's a big button there to click to review the show in one of those 2 platforms, and we would really appreciate it.
Number 2, we have been building out several directories, portals with information about the kinds of technology products that lawyers need and use. We have a portal for law practice management software, virtual receptionists, credit card processors, timekeeping and billing software. And here's the thing, we really need your input on those portals. So please visit those pages and review the software or the services that you have tried and tell us what you like or don't like about it, because your input is vital to those pages. You can just go to lawyerist.com, click on the nav menu under topics, and you'll find those pages. Please find your software and leave a review. We'd really appreciate it.
And really, not just the software you're currently using, but any product or service you've ever used. Even if you don't use it anymore because you don't like it or it doesn't work for you, those reviews are useful to other lawyers too. And so then our number 3 ask is, if you haven't already, we want you to join our community. Join the Lawyerist tribe by becoming an insider. And it's a free thing to join, but allows us to engage more deeply with you and understand the needs of your practice and your firm so that we can provide better support to you and so you can get to know other lawyers in our community. So to join the Insider, again, it's free. You just go to lawyerist.com/insider and you can check out. You'll get some access to free downloads, an invitation to a free Facebook group of some of our favorite people, and some other stuff. And it's free. And we'd really love to have you join the Lawyerist tribe as an insider.
Okay, so those are our asks, and we'd really appreciate it. Doing this podcast is a lot of fun, and this is a great way that you can thank us for it. So we're going to hear briefly from Alexis Martinelli, who is going to make her case for why most small firm lawyers should consider launching estate planning practices. And after that sponsored interview, we'll have my conversation with Shannon Salter, which I think you'll love.
My name is Alexis Neely. I've been in private practice as a lawyer since 2000. I went out on my own in 2003 after working at Munger, Tolles & Olson as an associate attorney for 3 years, and realized that the traditional law business model is broken. So from 2003 to 2006, I created a new law business model serving families and small business owners in a new way and built a $1 million practice while I was also raising my little kids and going going through divorce, and in my fourth year, worked in that practice just 2 to 3 days a week, still bringing in $1 million of revenue for that year while I wrote a best-selling book on legal planning for families and started doing a bunch of TV and really realized that I needed to teach this model to other lawyers, which is what I do today.
Great. So, Alexis, you wanted to tell people that estate planning is the perfect practice area for most lawyers. I'm a little skeptical because you say even if lawyers have never considered it before, they should be doing estate planning. So why? Tell us why.
Yeah, so there's really two reasons, two sides to this coin. The one is the impact that you can make on your community. I know that there are so many lawyers out there who are unfulfilled with the practice of law. They went to law school. They wanted to make a difference in their clients' lives. They wanted to make a great living. And then they came out of law school, and that's just not what's happening. They are tied to the billable hour, or they can't even get a job, or they're working way too much, or they have zero control over their schedule. And estate planning, or, by the way, they're not feeling as if they're really making a difference in their clients' lives. And estate planning actually solves all of those problems when done in the right way. Most lawyers are not doing estate planning in the right way, but when done in the right way, it actually makes a huge difference in your community. It is really exciting, and I know we didn't get that in law school. Most of our wills and trust teachers made it seem really boring and dry. It's not like that at all when you're doing it right. And you can have complete control over your schedule, and you can make a great living while you're doing it. And you can dial it up or dial it down. So you could have a small part-time practice working from home, totally virtually. You can have an office with multiple attorneys in it, like I did. I today have a virtual practice. I don't have a big office anymore. And you get to decide. And so I think it's the best practice area because to me it checks all the boxes other than going out there and, being in litigation. But I tried out the litigation thing, and while I liked it, I didn't like having to be in depositions until 11 o'clock at night, and I didn't like dealing with adversarial opposing counsel, and I didn't like the woman that I had to be in order to be a great litigator, whereas I really love the woman I get to be being an estate planning lawyer.
Okay, so I'm guessing the reasons that you gave for why people ought to try estate planning don't necessarily resemble all of the estate planners' practices who might be listening or people who dabble in wills and trusts. So what are the mistakes they're making?
Yeah, so the big mistakes that most estate planning lawyers are making is that they are doing estate planning the way that we were taught in law school, which is forms and documents. And you're right, doing it that way, it does pretty much suck. And not only does it suck for you, but it sucks for your clients too. And I learned this firsthand when I saw a number of failed estate plans throughout my own life, starting with my father-in-law, who spent $3,000 on an estate plan when I was in law school. He died, and we were stuck dealing with the probate court and his ex-wife, and I thought for sure his lawyer must have committed malpractice. And then I go to work at one of the biggest law firms in the country and find out, nope, this is actually common practice. And then I survey lawyers throughout the country who are doing estate planning. I find out, nope, this is common practice. And that's when I really began to discover that most estate planning lawyers or most lawyers who are doing wills and trusts, even just dabbling in it, are actually failing their clients. And by the way, they're also failing themselves, Sam, because it's not a great way to practice law. You know you're not really making a difference. You know that what you're providing is nothing more than somebody could go online today and do themselves on, one of the big document providing services, Rocket Lawyer, LegalZoom. There's, so many of them today. So that is not a way to love your law practice serving families or small business owners, but there is a way that you can do it. And it just requires you to shift the way that you look at what you're doing for your clients and how you're doing it. And then you get to serve families and business owners in your community in a way that has them give you gifts, refer you to all their friends, family, clients, and colleagues, be so happy to be working with you. And that's pretty rare for us as lawyers. And so when you do it right, it's actually feels really good to you, feels really good to your clients, and lets you have control over your schedule and make as much or as little money as you want.
So if you'd like to learn more about how Alexis thinks you ought to be building your estate planning practice, or if you're curious and you want to learn how, you can visit estateplanningsrules.com. That's estateplanningsrules.com to learn more and download a white paper that will introduce you to it. Thanks, Alexis.
You're so welcome.
Hello, my name is Shannon Salter. I'm the chair of the Civil Resolution Tribunal, Canada's first online tribunal. And by way of training, I'm a lawyer and have a history of sitting on administrative tribunals as a decision maker, and also previous to that, practicing civil litigation at a Vancouver firm.
Wow. I'm so excited to have you here. And quickly, shout out to Spencer Keys, who is a BC lawyer who I believe you know, who listened to our podcast with Professor Ben Barton and said, Sam, you've got to interview Shannon Salter. And so here we are.
Yes, thank you, Spencer.
So I have lots of questions, but I think we should probably just start with what is the Civil Dispute Resolution Tribunal? Is it CRT? Is that what we can call it?
We can call it the CRT, yes. It's the Civil Resolution Tribunal.
So what is it?
So the CRT is the first online tribunal in Canada, and as far as we knew, the first one in the world as well. What it is an administrative tribunal. We've got hundreds of them here in Canada. Each of them have responsibility under legislation for particular kinds of disputes or decisions that need to be made. I think in the U.S. you would call these administrative courts. In Canada, they're not courts, but they are part of the public justice system. So the result of somebody who has a dispute that comes to the CRT, at the end of the dispute resolution process, they get a tribunal order that's enforceable as a court order. So the CRT has jurisdiction over two kinds of disputes right now. The first are everyday neighbor disputes that happen in condominium buildings, and the second area of disputes are small claims, $5,000 or under. And small claims, as you probably are familiar with, are your everyday kind of consumer disputes, debt, contract, personal injury issues, that kind of thing.
So the significance of the tribunal part is that this was legislatively created, not court created.
That's right. And one of the things that makes the CRT distinct compared to other online dispute resolution projects around the world, or ODR projects, are that it is the first one that's publicly integrated into the justice system. So you see a lot of ODR projects like Modria and others that were really the product of for-profit corporations or not-for-profit organizations, rather.
Yeah.
And they operated outside the public justice system to provide people with an alternative to that justice system. And that's been really valuable in all kinds of ways. But in my view, really the potential to really transform the justice system requires that online dispute resolution and modernization happen within the public justice system.
So, I mean, small claim courts are things that we're all familiar with, and it sounds very similar. But is it purely optional, or is it the kind of thing where if you want to bring a small claim, the court is going to either demand or strongly encourage you to go through the CRT first?
So the CRT is mandatory for the kinds of disputes within its jurisdiction.
Oh.
So if you have a neighbor dispute in a condominium in BC, or you have a small claims dispute, $5,000 or under, you have to come to the CRT unless the court gives you an exemption on a case-by-case basis. That hasn't really happened so far yet. So we have exclusive jurisdiction over all of those kinds of disputes in British Columbia. Now, that doesn't mean that somebody who is not comfortable with technology or doesn't have access to a computer is forced to go online. We offer a variety of ways to engage in the dispute resolution process. So we have mail and telephone-based services in addition to online services. But one thing that's really surprised us is the overwhelming demand for online services. In a nutshell, basically nobody uses our paper forms.
Wow. Okay, so from the consumer user perspective, I'm pissed off at my neighbor because he pulled a tree out of our yard or something like that was annoying him. And so I want to sue him for the cost of the tree or something like that. How do I even find out about the CRT? Am I likely to walk into court, or am I going to be Googling how do I sue my neighbor, or how will I even find out about it?
We know from research that where people go first to find out what their options are is online for the most part now. So hopefully when you Google condominium or neighbor dispute or small claims in British Columbia, our website pops up first. And we've designed our website and really all of our technology to look very friendly and easy to use. We aim for about a grade 6 reading level for all the content we create. And so somebody who comes to our website with that kind of issue, first, before they file a claim, has to go through something called the Solution Explorer, which is a guided pathway or expert system, which is just a tech way of saying it's an integrated, interactive questionnaire. So we spend a little bit of time first with people, or at least our computer system does, helping them to better understand their legal problem and to give them plain language legal information up front, as well as some self-help tools like template letters that they can use to, for example, send their neighbor a letter outlining their position and offering to resolve the dispute somehow.
Without even going through the CRT or any other court.
Exactly. And this is important for a few reasons. One is that we know that for most people, they will not see a lawyer for these kinds of issues, and they may feel very much wronged, but in fact may not have a legal issue. In the sense they may have a problem, but not a legal issue.
Well, and even if they do, it's way easier to just resolve it.
Exactly. So the goal of the Solution Explorer, which is basically, we ask you what your problem is, and you select from options, and then that tells us what kind of information or what kind of question to ask you next. And what it does is allows us to get a pretty high degree of granularity for people's problems. So if you ask people questions online and you take their answers, it lets you give them very targeted bits of legal information, as well as really targeted tools. So the template letter I talked to you about before that you can send your neighbor happens at the end of having asked some questions and received some answers from the user. And that information is used to populate the template letter, for example. So we want to give people those tools up front so that ideally, as you say, they never even file a dispute with us.
Yeah.
But even if they have to, our hope is that by having that upfront legal information, they can take a more rational or reasonable position in terms of what their next step should be. Is it worth filing a claim? If it is worth filing a claim, what should my position be in the mediation phase, which we haven't talked about yet, but is really the core of the CRT, is collaborative dispute resolution.
So I want to talk about that, but one thing struck me while we were talking about how do people find it and they arrive at it. I'm wondering if you spent time thinking about how to give the message that this is an actual official thing. Because like when I'm Googling stuff, I land on web pages, and one of the first things I'm always doing with that web page is like, is this real? And let's face it, your website looks a lot more like something I would expect to see from a fairly tech-savvy startup than from a court system. And when I went to visit it, I was like, am I in the right place? This actually looks too slick for a court. But I'm wondering if you
I'm going to take that as a compliment.
Well, I mean it as a compliment, but it's also like, it's a funny user design problem that I hadn't really thought about, which is if you're trying to convey officialness, sometimes it can be too good looking and too slick.
This is actually something we spent a fair bit of time thinking about, especially because when somebody does file a claim with the CRT, once they determine that we are authentic and legitimate and file a claim, what we send them is by email a dispute notice that they then have to serve on the other parties. And the dispute notice, too, doesn't look so much like a court form. It's really much easier to understand. It has our logo. It's pretty clear in plain language.
Which, again, is like, that's not what you expect from official documents.
Right, and especially if you're receiving this by email, you may well think this is not actually an official document. So we've spent a lot of time making sure that we get the word out about this. So well before we opened, at least a couple of years before we opened our doors, we spent a huge amount of time doing town hall meetings, doing media interviews, webinars with community advocates and librarians, going to all the places where people go to seek legal help and advice, and making sure that those intermediaries understand the CRT and can direct people to the right place. So a lot of it is an education piece. But so far, surprisingly, we haven't had too much confusion from folks about whether or not this is a quote-unquote real thing that they have to pay attention to.
Okay, so thank you. I kind of love the details about design and stuff like that people might not be thinking about, and it's neat that you tried to sort that out. Let me go back to where we were going next, which is, okay, so somebody does decide to start a dispute, someone responds, and then there's a mediation negotiation phase. Say more about those pieces of it.
Yeah,
or did I skip something important?
No, you're exactly on the right track. And I should just take a step back and say that we get a lot of attention for being an online tribunal, because I think in the legal world or the court world, if you do something online, it's very exciting, even though it's not particularly revolutionary in terms of modern society.
Throw
generally.
AI in there and people's brains will explode. Yeah, it'll be.
and the Solution Explorer is a very basic form of AI, although we are looking at ways of using AI in different ways as well. But so in my view, though, the whole online piece is secondary to our greater mission. Our mandate is to provide more accessible, inexpensive, less complicated, more timely dispute resolution for people. And we know that one of the ways to do that is to allow them to participate wherever, however they are. And so using online tools is a good way of doing that. Another good way of doing that, though, is by helping to support people to reach an agreement wherever possible. This is important because we know that people tend to be more satisfied with problems that they solve by agreement rather than having a tribunal member like me or a judge even make a decision.
Yeah.
And we also know they're more likely to stick to their side of the bargain if they reach an agreement rather than even if they are subject to a court order, which is a bit surprising. So we really try and support people along the way to reach an agreement using as few of their resources and as few of our resources as possible in the early stages. So the Solution Explorer that I described, that question and answer thing, is automated. It doesn't cost the user anything, and it doesn't use any of our staff time. The next phase, though, is the negotiation phase, and that's where the parties have filed their claim, they've responded, and then they're invited to enter this neutral virtual forum where they can basically just start talking. And surprisingly, that resolves a considerable number of disputes as well, even though there are no staff members involved at this point. Just providing people with a forum where they can start to discuss the issue is pretty effective in certain kinds of cases.
So does that mean they can invite their opponent, as it were, in, and they have a private kind of chat room?
That's right, except we're the ones who do the inviting, or at least our computer system does. So once a dispute is filed, our computer system will send an email to both parties inviting them to come into this neutral chat room and start to talk. We incentivize that by waiving the fee for creating an order if they're able to reach an agreement. But basically, it's very low intervention on our part. And they're doing this while they're waiting for a mediator to be assigned. So it doesn't take any additional time in the process, but it makes the best use of these natural kind of pauses in the dispute resolution process.
And I notice on the website you have some language about abusive behavior. And I imagine that on the one hand, not being face-to-face might be very helpful in facilitating an agreement. But I can also imagine, being a person who has spent a lot of time on the internet, that it can go wrong and people can kind of be assholes to each other. Does that happen a lot?
It hasn't happened very often. I think we've all seen the comment section for various blogs or newspapers and had that anxiety. But I think a key difference there is the anonymity that sometimes encourages people to behave badly online. People are not anonymous in the CRT process. They also are aware that CRT staff are occasionally monitoring these chats. We also have, as you pointed out, codes of conduct for participants, and if they breach those, there can be consequences. So they can be subject to a non-compliance order from a tribunal member. Their participation in the process can be limited, and there can be other cost consequences as well. So we have tools to make sure that people adhere to the rules of the tribunal and treat each other respectfully. We have a zero tolerance for harassment and bullying, but I'm happy to say that hasn't happened very often.
Very cool.
So if that does happen in the negotiation phase, if people start getting too heated, there is a button to report abuse, and then the negotiation phase is just paused.
Gotcha.
Until a mediator can come in and start mediating.
How long does that typically, does the self-negotiation or self-motivated negotiation go before a mediator is assigned? And I mean, how many mediators are there? Is this a big pool or a lot of things getting resolved before that?
I'd say a small percentage of cases are being resolved in the negotiation phase, but it's early days. We only rolled out that feature a couple of months ago. So we're experimenting, we're doing a lot of A/B testing, and we're learning a lot about that. There is a waiting period for a mediator to be assigned. We have about 14 or 15 mediators, and we're hiring more every few months. But people do need to wait typically about 4 or 5 weeks for a mediator to be assigned. We call them facilitators in our world. And once the facilitator is assigned, that person will go in and start communicating with the parties. And it's very, very flexible. So, for example, if two parties are in a dispute and one of them is only really comfortable on the telephone and the other is sort of happy to be online, the facilitator will likely organize a telephone conference call because that's what's most comfortable for both of the parties. Similarly, the facilitator can accommodate all kinds of different schedules. So if you have a single parent who has a day job and kids and is only really available to respond or work on a dispute in the evening, and they're in a dispute with a shift worker who has a totally different schedule, that's fine. That's one of the ways that using online tools offers people more accessibility and flexibility because people can go in and respond when they need to. So the mediation there might happen through our online portal or through email.
So I was going to ask you about the technology that powers this, and it sounds like it is mostly a communications platform. Does that sound right?
That's certainly one of its functions. It's also a case management platform. It has this artificial intelligence component. Pulling back the curtains, the CRT software is built on Salesforce.com.
Huh.
I'm not sure if you're familiar with Salesforce, but
yeah, definitely.
For your listeners who may not be, it's a customer management database software. It's designed primarily for e-retailers. But if you think about it, the kind of information that you need to collect in that context isn't that different from what a court needs to collect for a case management system, right? You've got names and addresses and file details and documents that need to be attached. You have tasks that you need to create for staff members. So that's the cloud-based software that powers the CRT. And then what the Ministry of Justice in British Columbia has procured to build, and this is pretty much entirely built now, is two lightweight pieces or web applications that integrate with Salesforce. One powers that Solution Explorer question and answer platform I talked about earlier. And the other one, as you say, has a big communications function. It includes our online intake form, different tools for citizens to take different steps in the life of their claim. It includes evidence handling, case management functions, the negotiation platform, that kind of thing.
So is this something that you're constantly developing, or was this built and now you're using it and at some point in the future you'll do an update?
No, we use an agile development process, and so it's never going to end probably. And I think that's a good thing.
Yeah,
so
absolutely.
We do a huge amount of user testing, and I can describe our process with that if you'd like. I think it's different to undertake rigorous user testing when you're developing software in a public justice system versus a private software company that can pick its market, for example. But nonetheless, user testing is obviously extremely important, and we've done tons of it. We keep doing tons of it. So we're really committed to continuous improvement and also rolling out software in a thoughtful kind of incremental way. So we started with the Solution Explorer. We rolled that out in beta. And then we opened our doors for these neighbor disputes with a pretty limited set of technology. But as we keep moving forward and keep learning more, we develop different functionality and keep rolling that out in an agile way.
So I have so many questions, but we need to take a break to hear from our sponsors. And when we come back, I think rather than just geeking out on your design process, which I would ordinarily do, I think I want to talk about how you measure success and then talk about kind of the implementation process, how you got this done and how someone might replicate that. So we'll be back in just a few minutes.
Did you know that attorneys who accept online payments get paid 39% faster on average than those using traditional payment methods? With LawPay, the only payment solution offered through the ABA Advantage program, you can accept client payments online, via email, or in person. No equipment needed. Visit lawpay.com/lawyerist to sign up and get your first 3 months free. Trust the only payment solution developed for attorneys and recommended by 47 state bars. LawPay. Being a self-employed lawyer is hard enough, which is why dealing with your day-to-day paperwork on top of it all shouldn't have to be. FreshBooks makes ridiculously easy-to-use cloud-based time and billing software that will help you work smarter, get paid faster, and become more organized. With FreshBooks invoicing, you can create and send polished professional invoices effortlessly in mere seconds. FreshBooks can set you up to receive payments online, which can seriously improve how quickly you get paid. You can track your time either by using their mobile app or your desktop, meaning you'll always know what work you did, when you did it, and who you did it for. There's also a super handy deposit feature so you can invoice for a payment up front when you're kicking off a project. To feel the full impact of how FreshBooks can change the way you deal with your paperwork, FreshBooks is offering our listeners a 30-day free trial. To claim it, just go to freshbooks.com/lawyerist and enter lawyerist in the How Did You Hear About Us section.
Ruby Receptionist is a live, remote receptionist service that is dedicated to helping lawyers win clients and build trust one happy caller at a time. From their offices in Portland, Oregon, Ruby's friendly, professional receptionists ensure exceptional client experiences by answering calls live in English or Spanish, transferring calls, taking messages, collecting new client intake, addressing common questions, making outbound calls for you, and more, just like an in-house receptionist at a fraction of the cost. More importantly, they sound like they're sitting in your office. For a special offer, visit callruby.com/lawyerist2018 or call 844-715-7829. That's 844-715-RUBY. Okay, we're back. And like I said, I'm tempted to ask you all about user testing. I am curious about that. But maybe just a couple of things about what's different about user testing in a public environment? Because you dropped that, and to me, that felt like a meaty thing that I wanted to dig into.
Yeah, I think there are some key differences. So going back to what I said at the beginning, private ODR software companies or even not-for-profit ODR projects have some key differences from a publicly integrated one like ours. One is that a private software company can pick its market segment. It can decide this product is for middle-class users who have this particular education background and that particular skill set.
Right.
When you're designing technology for the public justice system, you don't have that luxury. It has to work for everybody. You have to account for everybody, including the most heavily barriered, marginalized user, all the way up to somebody who files 50 disputes a day. And so that really drives the way that you do user testing, or at least it drives the way that we do user testing. So the way we do user testing in a whole variety of different ways, but one key continuity is that we always start with the most heavily barriered users in society. So we always start with community legal advocates who serve clients who may be low income, may have mental health issues, may have addiction issues, may not speak English as a first language, may have a physical disability. And we have a very generous roster of advocates who are the first step whenever we design anything new. And this could be technology like the negotiation platform, but it also can include things like our forms, our rules, a new policy on fee waivers, for example. So we always start with them. They always are very generous with their feedback, and we make pilot changes based on their feedback. Then we move on to mainstream public testing. So we recruit members of the public to test all of these things as well and give us feedback, and then we make a ton of changes there. And then we end with the lawyers. And we end with other, more sophisticated actors in the justice system. So
because really, lawyers don't actually have much of a role to play in this.
They don't, and our assumption is that if it works for the most heavily barriered members of our society, it will absolutely work for lawyers.
That sounds a lot like Microsoft's accessible design principles, which is exactly what you just stated. If you solve the hardest problems by designing for the most challenged people, the rest of it will pretty much take care of itself.
I think that's true. That certainly worked for us, and it's worked not only to design really simple software and simple forms and simple rules, but it also means that we've been able to build a lot of trust with people who haven't always been well served by public sector technology, and sometimes have felt quite disenfranchised by it, in fact. So that's been really valuable for us as well. We've managed to rub off a lot of the rough edges of the technology before we even start coding. So one of the key lessons we learned through launching the Solution Explorer is that it's really tempting, even in an agile process, to say, well, we're going to just test that in beta. We'll wait till beta to figure that out. But beta is pretty far along.
Yeah.
And so it's much less expensive, and you get much closer to the mark if you start testing in the conceptual design phase early with the people who are likely to have the most difficulty. And that leads to much more sustainable, usable technology later on.
Well, it sounds like the order of your testing also reflects reality. I was having a conversation with a friend, an old family friend who's a judge recently, and he was expressing frustration about constantly having to deal with pro se parties. And we know each other well enough that I kind of exclaimed at him, I mean, come on, like only 20% of the people you see are represented, right? That's not your core demographic. You need to be building your justice system around the 80% who aren't represented. And I'm a lawyer, and I'm an advocate for lawyers, and I love lawyers, but I'm also interested in access to justice, and I try to advocate for that. And it sounds like your system takes reality into consideration that most of the people using this are not going to be lawyers. And so lawyers really ought to be a secondary consideration when you're designing something meant for the public like this.
Yeah, this is my view, and I absolutely share your perspective on that. I find it very frustrating when lawyers talk about self-represented people as though they're an obstacle to the justice system, that if we could just get them out of the way, we could get on with the practice of law.
Give them a lawyer, any lawyer, and then we'll know what to do with them.
Right, but as you recognize, that's not the reality. And it's increasingly not the reality. And moreover, the justice system actually belongs to those people, and they're entitled to use it. And it's not their fault that they come into courthouses and don't understand the rules or the Latin or the order or the even where to go. Those are design problems, but it's not their fault. They're not there voluntarily, most of them. They wouldn't choose necessarily to do this. We know it's extremely stressful. So our view is, isn't it our responsibility to build the justice system around the people to whom it belongs? To go to where they are, to understand that people have a bundle of abilities and skills and challenges and limitations, and to account for all of that while bringing the justice system to them. Sometimes that's a physical place. We have big rural areas in British Columbia, as you do in many states in the U.S. as well. And so physically it's hard to get to a courthouse for some people. Yeah. But there's other challenges as well, as we've discussed. So it's exactly, that's exactly our perspective, is that the justice system belongs to the public. It's our job as a public justice entity to build it around their needs and to make it accessible. And that's what we do through human-centered design.
Well, and if it's not clear to listeners who are private lawyers and are wondering if I've just thrown them under the bus, this is the exact same design process that you need to go through in your own practices. As Shannon said a minute ago, a private firm gets to choose their target demographic, which private lawyers do too, but then you have to design for it, and you take your demographic as you find it, and you have to build something for them. I'm now at risk of spending the next hour geeking out with you about design and things, and so
I would happily go with you down that rabbit hole.
Well, let me switch gears and ask you about success, and especially because of the way you're doing this, I'm confident that you have been setting targets and trying to assess whether you're getting to them. But when you started out, how were you going to measure success, and how has it measured up?
It's an interesting question because it's a bit of a moving target. When you have a mandate, as we do, to provide dispute resolution services that are more affordable, more timely, more accessible, more proportionate, all of those things, you can think of many different ways that you might measure that. Some of the constants have been, what is the time to resolution? How long does it take? How much does it cost for a person to get there? How complicated is it? How satisfied are people with the process? Do people think the process is fair? How often does the court overturn one of our decisions on appeal? And we haven't talked about the adjudicative phase, but if mediation fails, then a tribunal member makes a binding determination, and that's appealable to the courts. So all of those things can be measured, and we are measuring all of those things, as well as, frankly, a million other more granular things as well. So our evaluation framework is highly detailed. But I think the key indicators, one of the most important key indicators for me is how do people feel when they're going through the process? If you're designing around the public, and the key is that they are confident in the process and that they think that they've been treated fairly and they understand what they've been asked to do, I think we're making a pretty big leap forward in terms of access to justice. So we collect all kinds of qualitative data and quantitative data. Some of the qualitative data we collect are through user satisfaction surveys, and this is not something that's typically done in courts or tribunals here. But we ask people who have gone through the process not whether or not they agree with the decision. That's a question for the court on appeal. But we ask them questions like, did you think that you were treated fairly? Were you treated with respect by CRT staff and members? Did you understand what you were being asked to do? How did the technology work for you? These kinds of questions. And our satisfaction ratings are really high. So far, about 90% of people say that they feel that they've been treated fairly. That the process, about 80% of people say that they found the process clear and understandable. And I would hazard that compares pretty favorably to the way people tend to feel going through the typical court process.
Oh, come on. It's not even close.
I'm being
Nobody
diplomatic.
feels that good about going through the court system.
But so I guess my point is the technology is great because it allows you to collect all kinds of data, and we use that and analyze that, and there's a story to tell there as well. But I think just as important is the qualitative data, because that affects people's confidence in the administration of justice, whether they feel that, in a nutshell, they got a fair shake or not, even if they disagree with the outcome. So that's been pretty heartening. But we are very cautious and we're careful to be very humble about this because it's always a work in progress. Mm-hmm. The good thing about all this user testing is that it keeps you really humble, and our team is pretty much egoless at this point because we've gone back so many times to the public, and we've had so many cases where some small feature that we thought collectively as a group of lawyers and IT professionals was going to be wonderful and everybody would adore it, only to have the public tell you it's a disaster and it's horrible and you should kill it right away.
I'm still working on that. I'm impressed.
Well, I think it's something you constantly have to keep in check, because the temptation is to make assumptions about what the public preference will be, and also to get too attached to ideas that you think are great in theory but just don't work in practice. So keeping really connected to the public needs through user testing has been really, really helpful. And we keep doing that now as well. We will never stop doing that.
Are you able to say anything about the potential burden on the justice system that CRT may have taken up? I
can tell you in rough strokes that when we assumed jurisdiction over small claims disputes, $5,000 and under in BC on June 1st of last year, that we anticipated through statistics that would take out about 40% of the small claims court's work. Mm-hmm. So in other words, small claims are heavily concentrated at the lower end of the monetary spectrum, and this is borne out so far through our analytics. About 40% of those cases are now taken out of the court system and are being handled through the CRT. And that's important because it allows the court system then to devote those resources to reducing wait times for criminal trials and family trials, frankly, cases where the interests at stake are pretty important.
If someone were to try to get something like the CRT implemented in their own, say, state or county, where would you suggest they start? I mean, I know this is legislative, so maybe you just start knocking on doors of your legislators, but I'm curious how you would recommend people start trying to get something like this done.
Yeah, and that's an interesting question. I've seen it start to happen in different ways in different jurisdictions around the world. So I mentioned, I think we were on the forefront, but it's exciting to see that there are projects now in all kinds of different jurisdictions, and some of them are being driven by the government, as was the case here in British Columbia. But a number of them are being driven by the judiciary itself. So you see that in the courts in England and Wales. You see it in the courts in your jurisdiction in Utah. The Utah state courts are launching an ODR small claims project, and that was really spawned within the court system. And so it can happen, I think, in different ways. But I think the key is having a strong champion who has decision-making authority, who is committed to seeing it through despite various setbacks and road bumps, because it's never a smooth process. But I think the other key important thing there is change management. We spent a huge amount of time on change management. I think that might be easier as ODR becomes more acceptable and known and has a better or more of a track record anyway. But for us, we had to spend a lot of time talking to stakeholders, talking to lawyers, talking to the public, helping them to really understand what the vision is and alleviate some of their anxieties about what it might mean for the justice system. If your listeners are interested, the National Center for State Courts Joint Technology Initiative just released 2 reports on ODR. One is a set of case studies around the United States and other jurisdictions, and the other is a set of recommendations for jurisdictions that are looking at instituting an ODR process. So I would recommend both of those reports to you. Not just full disclosure, I did sit on the committee that helped write them, but I think they are a solid starting point.
Very cool. We'll try to include those links in the show notes. Shannon, thank you so much for being with us today. I really enjoyed hearing about the CRT and how it has been developed, the role that you've had in designing it and bringing it to the public. So thank you so much.
Thank you very much, Sam. I've enjoyed it.
Make sure to catch next week's episode of the Lawyerist podcast by subscribing to the show in your favorite podcast app. And please leave a rating to help other people find our show. You can find the notes for today's episode on lawyerist.com/podcast.
The views expressed by the participants are their own and are not endorsed by Legal Talk Network. Nothing said in this podcast is legal advice for you.